suppress the evidence which was unlawful.
The committee will come to order. Members will be continuing to come in, and the ranking member and full committee chairman and ranking member, when they arrive, will make their opening statements, and but we won't interrupt testimony. Today we're here for the Subcommittee on Courts, Intellectual Property, and the Internet, and without objection, the committee chair will be authorized to declare recesses of the subcommittee at any time. We welcome today's hearing on the judicial branch and the effective administration of justice. Today's hearing is about ensuring the proper oversight measures exist in our court system and the justice is administered fairly by those who live up to the ethical standards required of our judges. Respect for our government seems to be at an all-time low. Various scandals at executive branch agencies seem to be on a rise on a regular basis. A member of Congress from Philadelphia was recently convicted on 23 counts of fraud and racketeering before resigning just 2 weeks ago. It is absolutely critical that the judicial branch be an honest broker when called upon. However, the judicial branch is the least well-known branch, and many say the smallest, although its power, when addressed, is considerable. It also has historically lacked transparency. It is time, however, for the judicial branch to come from the shadows. Americans expect an open and transparent government. Americans expect disclosures of potential conflicts of interest along with financial disclosures. Their expectation, rightfully so, belongs to 3 branches. Finally, they expect to see their government officials doing their job. While C-SPAN may not be everyone's favorite channel today, it is an important part of making government accessibility to its citizens. There are cameras in this hearing room today, and citizens can judge for themselves whether or not elected officials are doing what they were sent to Washington to do. And I might note that today's hearing will be archived and available for immediately and for years to come. Depending upon their offices, elected officials face the voters every 2, 4, or 6 years. Federal judges, Article 3 federal judges, have a lifetime appointment, while other federal judges have long-term appointments. That was set by the U.S. Constitution, and we respect that with the absence of term limits, the court is in fact a permanent body, once confirmed, unaccountable, except in the case of high crimes and misdemeanors. Judicial transparency is also lacking elsewhere. For example, the court system has no inspector general, or, in other words, no watchdog of the judiciary. There are only a few cameras in a few courtrooms on a test basis, and the cameras in the courtroom are controversial and rare. In the Northern District of California, involving the NSA data collection, cameras were permitted, and I'd like to take this opportunity to show just a little bit of what was voluntarily captured, if I may.
Press the evidence which was unlawfully obtained or derived from electronic surveillance. Obviously, that does pertain to suppression motions. But then it also goes on to say, or otherwise grant the motion of the aggrieved person. And that reinforces the what 1806F says in saying that it's a broad procedure that applies to any other motion brought under any other statute or rule.
Before you go on,
yes.
I don't know that you've answered the question. What you're saying is certainly helpful, and you're basically attempting to support what Judge Walker did. But let's start with the district court, and I asked the defendants a question about whether the court should reverse the decision by the district court. Disregard may be the better word, follow may be a better word, find persuasive. So what is the legal impact of Judge Walker's decision, and to what extent is it binding or persuasive on this court. And I understand you're arguing persuasive in the sense of Judge Walker got it right, but as a matter of law, and that's why I asked, do the defendants have any authority, what is the legal impact first of Judge Walker's decision, and then of course the Ninth Circuit not reviewing the district court's finding?
Could you pause it right there, please? Thank you. Whoops. Okay, perhaps no pause button. If we can figure out ways to consistently broadcast, capture, and retain this type of information that you saw in the case of what was in fact a case involving a sensitive national security issue without jeopardizing secrets, then I believe that we can find a similar way for the purposes of archiving and, when appropriate, capturing evidentiary events in the courtroom. And I want to be very brief, but there are a couple of areas that people often forget. Although we capture a transcript and in many cases a audible recording and have for years, one cannot necessarily capture a pointing at a document or a misrepresentation that may in some way be captured by a video. Additionally, any disturbance within the courtroom, it cannot be effectively captured by a transcribed interview, but in fact, a video can capture misconduct. This could lead, in the case of disturbances and or some action of a person, to have facial identification. These are all sensible reasons over and above the basic question of, would the American people feel more comfortable if they could sit in their own home and watch exactly what the jury is watching and what the limited amount of people in the audience are able to watch in any case at any time before the federal court. Just like the Thomas and Pacer system is fundamental to making the court transparent, Americans believe that paying 10 cents a page for those documents is not in fact giving them the transparent access. So lastly, as I close, one of the important parts of a video capture would be that they would receive in real time and by recorded means the ability to capture any and all information that was presented to the jury without having to pay for it. As I said earlier, I will recognize the ranking member when he arrives, but at this point we will go on to introducing our witness. Today I want to thank our distinguished witness for taking time out of his busy schedule to be with us. The witness statements will be placed in the record in the entirety, and you know how the lights work because you've done this before. And additionally, this is the opposite order I'm used to. I want to introduce our witness, Mr. James Duff, Director of the Administrative Office of the United States Courts. In other words, the man who spends about $13 billion in various ways on our behalf. And pursuant to the rules of the committee, Mr. Duff, would you please rise to take the oath? And raise your right hand. You know this from other parts of government. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. Let the record indicate that Mr. Duff answered in the affirmative. Again, you're the only witness. You are the person most knowledgeable of the spending and who, as a matter of your job, works closely with the justices of the Supreme Court and the other administrative judges around the country. So I'm not going to limit you in your opening statement strictly to the 5 minutes, but as close as possible. And with that, I will recognize the chairman of the full committee for his opening statement. Mr. Goodlatte.
Thank you very much, Mr. Chairman, and I appreciate your holding this hearing. America is a nation of laws. With laws come disputes and differences of opinion. The American people look to our nation's courts to be efficient, transparent, and fair arbiters for settling disputes when they arise. To achieve these expectations, the judiciary must efficiently administer justice, despite the fact that the judiciary receives only a small portion of our nation's budget. As this committee has seen previously in the disastrous GSA renovation of the Poff Courthouse in my hometown of Roanoke and in other wasteful GSA expenditures, not all spending on judicial needs is directly within the judiciary's control. However, it is healthy for Congress, which has responsibility for authorizing funding for the judiciary, to review spending by the judiciary and have an opportunity to ask questions to assess the efficiency of that spending. In addition to efficiency, the American people expect transparency with respect to judicial actions. Transparency bolsters Americans' trust in fair and independent judges who are above ethical reproach. The PACER system helps to deliver transparency and has enabled anyone with an internet connection to read court filings and decisions, much like Thomas, the legislative search tool, allows the public to see what members of Congress do on their behalf. However, Thomas, unlike PACER, comes with no direct fee. To be sure, there is a budgetary cost to operating both Thomas and PACER, but in today's interconnected world, Americans increasingly demand access to information, including court documents, freely and without a direct surcharge. Another possible way to deliver transparency is to allow Americans to watch court proceedings. Our hearing today is being webcast to anyone who wants to watch it, but hearings only a few blocks away at the District Court for the District of Columbia and at the United States Supreme Court will never be seen by anyone. The idea of allowing cameras in our nation's courtrooms is not a new one, but I look forward to hearing more about this issue today. In addition to the efficient and transparent administration of justice, the American people look to the judicial branch to be the fair arbiter of disputes that arise in civil and criminal contexts and expect impartial and ethical judges. While the vast majority of federal judges exercise their duties with the highest moral and ethical standards, regretfully, there have been recent situations in which federal judges have fallen short of these standards. For example, one judge in Alabama abused his wife and then lied about it to his colleagues before he resigned under pressure. Another judge appears to have engaged in deplorable conduct before he became a federal judge, only to resign on disability days after widespread news reports appeared about his conduct. To investigate ethical breaches like these, as well as to ensure that instances of fraud and waste are discovered and addressed, former Judiciary Committee Chairman Sensenbrenner and current Senate Judiciary Chairman Grassley have supported the creation of an Inspector General for the judiciary. While the judiciary has strongly resisted the creation of such an Inspector General, I look forward to exploring this idea further as well. I look forward to hearing from our witnesses today about these and other issues concerning the operation of the judiciary. And Mr. Chairman, I thank you for your forbearance and yield back.
Thank you, Mr. Chairman, and I want to take a moment to thank you for the work that you've done in guiding the areas of reform that you're looking forward in the court system. I serve at your pleasure, but I also serve at your guidance, so thank you. And Mr. Duff, with no further ado, please, you're recognized.
Thank you very much, Chairman Ison and Ranking Member Nadler, who's due to arrive, and members of the subcommittee. And I appreciate very much Chairman Goodlatte's invitation to appear before you, and I'm grateful for the opportunity to discuss the judicial branch and our goals and efforts to provide the most efficient and effective administration of justice in the world. We regret that Judge Rodney Sipple, who was to appear here today too, could not be present because of a death in his family, and our thoughts are with Judge Sipple this morning as we testify here before your committee. We ask that his written statement be included in the record.
Without objection, so ordered.
Thank you. One of the most distinctive features of our form of government is our independent judiciary and its administration of justice. When judicial representatives from foreign countries and developing democracies visit our offices, they are usually familiar with the constitutional structure we have in the United States. It provides for an independent judiciary, its provisions for life tenure for judges, and its prohibitions against any reduction of salary. But what has been very interesting to me is that our visitors are most interested in learning about the administrative office of the branch and our Judicial Conference of the United States, and how these administrative structures both operate and help enable the branch to maintain its independence. I would like to address some of those features here today too, as they also demonstrate how we strive for efficiencies in administering the branch. The judiciary is, of course, dependent on Congress for its funding, and we're very grateful that Congress has made us a funding priority in the past 3 budget cycles after sequestration. It is clear from our appropriators in Congress that we are recognized as careful stewards of public funds. And I would like to speak briefly as to how the judiciary is managing and being responsible stewards of those funds in its efficient administration of justice. And I focused on just 3 areas from my expanded written statement, which I also ask be submitted for the record.
Without objection, so ordered.
Thank you, Mr. Chairman. To summarize the 3 areas in my written statement very briefly, first, we've highlighted several case management practices that are implemented both by the courts locally and at the national level through coordinated programs that are structured in our judicial conference committees and the administrative office of the courts. We encourage every court to employ the best practices we've gleaned from local courts. A prime example of this is, in fact, electronic filing in our federal courts. This started in 1 court in the Northern District of Ohio, and now all federal courts have it. I would point out that, by contrast, some state courts still do not have this service, and it saves significant funds for the taxpayers. Second, we are effectively and efficiently managing public funds through workforce and resource management practices that include the utilization of magistrate judges, inter- and intra-circuit assignment of judges to courts with the heaviest caseloads, sharing administrative services among courts, and employing improved work measurement tools to determine our needs more accurately. Our senior judges, those who could retire but have chosen to continue their service, are frankly keeping the branch afloat. We are managing financial resources through a realistic budget formulation, and we've developed very strong working relationships with our appropriators and our work with them to find savings wherever possible at every stage of the budget process is paying great dividends. And we have employed cost containment initiatives for over 10 years now, even before sequestration. And those have enabled us, among other things, to bring down our rent projections and our space and facilities needs down. And the chairman, Goodlad, had mentioned our work with GSA and some of the issues we have had with GSA in the past. I'm very pleased to report this morning that we have an improved service validation initiative with GSA that is getting good results, and I think can save us as much as $10 million annually as we go through that program with GSA. We've also utilized an aggressive auditing program that relies on independent certified public accounting firms, as well as our staff of auditors at the administrative office, to audit our financial systems, our programs and operations that support the courts, among many other audits. All told, 205 separate audits were conducted in fiscal year 2015. And I would add that we respond routinely to GAO requests for studies, 12 such requests alone in 2014. Third, we are working towards enhanced access to the judicial process, even during austere budgets. Our caseload statistics fluctuate over time, but the overall trend since the last comprehensive judgeship bill was enacted in 1990 has grown far faster than the number of judges that we have. Our ability to stay current in most courts is a testament to our increasing efficiencies and the hard work of our judges and staff. There are, however, some districts that simply cannot keep up with the enormous number of new cases, and we therefore have asked the Congress to provide more judges in those districts with extraordinarily high caseloads and to convert certain temporary judgeships to permanent status. We also ask Congress to please be mindful of the judiciary's needs when new legislation is passed that adds to the workloads of the courts, such as in sentencing and criminal justice reform and immigration reform. Mr. Chairman, this is only a brief summary of my written testimony, which elaborates on these and other points, and I'd be very pleased to answer any questions you may have about that, as well as to address the issues you've raised in your opening statement this morning.
Thank you. And since we've been joined by Congressman Franks, Mr. Franks, if you'd like to, if you have questions, I'll be glad to take yours first.
Thank you, Mr. Chairman, very much. Thank you, Mr. Duff, for being here. Mr. Duff, you know, as you know, other branches of government have comprehensive disclosure and ethics rules, and I'm wondering if you think the judiciary should also have disclosure and ethics rules for all judges, including those on the Supreme Court, and should there be reforms to impeachment standards, or should an inspector general be appointed for the judicial branch?
Well, to answer them in order, we do have financial disclosure reports that are filed by our...
These are financial disclosures, not general ethics, correct?
Well, we follow ethics standards, certainly. We have codes of conduct within the branch, and we follow those, and they're modeled after similar codes. And with regard to...
I'm sorry, I don't mean to interrupt you, but these are written...
Yes, there are standards within the branch that, for conduct of judges, and we have a very robust system within the branch of overseeing and reviewing allegations of misconduct.
Do those apply to the Supreme Court?
Pardon me?
Do those apply to the Supreme Court?
No, sir. The Administrative Office of the courts and the Judicial Conference of the United States only oversees and works with the federal courts, not the Supreme Court. The Supreme Court has its own court administration.
Own everything, huh?
Yes, and it's a constitutional court, unlike which was created in the Constitution. The federal courts, by contrast, have been created by the Congress. So there is that distinction, and I should mention that I appear here today only on behalf of the federal courts and the federal court system, and not on behalf of the Supreme Court. Yes, sir.
Okay. Well, then I'll just move on here. What do you think the negative consequences, if any, have been to cameras in a limited number of the federal courthouses?
Well, we've had pilot programs, and we do permit cameras at the Court of Appeals. Only 2 such circuits are utilizing cameras now. The camera issue has been around for quite some time. We have very serious concerns in criminal trials. The ability to bring witnesses into cases are affected by cameras. Threats to individuals who appear as witnesses are very serious, and cameras publicize that and their images. There may be techniques to block that out, but they're not perfected. We've had a pilot program for cameras in the courts in civil cases in recent years. And we had a study done by the Federal Judicial Center as to the benefits and detriments of it in the pilot program. That was considered by one of our Judicial Conference committees, and it was determined that there is not at the current date overwhelming or pressing need to televise all trials at the federal court level.
Would it be fair to suggest that your assessment might be, what would be and let me just ask, what would be the net effect, do you think, on balance? Do you think it's been a positive or not?
I think where they were utilized in the pilot program, there was no recognized positive effect. In fact, if you look at the statistics in the pilot program that we ran, the individuals who were the litigants in the case, each party was given the chance to determine whether they would prefer or had any objection to it being televised or not. And the overwhelming majority said that they did not want it televised. And I would draw a and so it was a very small percentage of the participating courts in the pilot program that actually utilized cameras in the courtroom as a result. I would point out that there are distinctions between the branches and among the branches in this regard. Certainly our trials are open to the public. Anyone can go into the courtroom and attend. So they're not closed in that sense. The determination as to whether or not they should be televised is a different question, and there are different aspects of this that apply to the branches. The general public has no vote in the cases before a court. The courts are there to serve the litigants and the parties and to resolve conflicts. And so there are different aspects of perhaps the need for televised hearings, unlike by contrast with in Congress and your committee hearings and this committee hearing today. The public has every right and interest and a vote in many, and if not most of the issues that appear before your committees. So there's some distinctions in the branches, I think, that need to be recognized as we consider the question. And we are all for public access. The chairman has raised a couple of issues I know we'll address further this morning about the ability to access information from the courts and our opinions. Just as an aside, I would point out that our PACER, the chairman referred to our PACER system and the costs involved in our PACER organization within the courts. That was a determination, and you mentioned 10 cents a page for getting transcripts and so forth. The opinions of the courts on PACER are free. 70% of the users in the PACER system do so for free. The costs involved to the courts are passed on to the users, and most of them are institutional users that have to pay for access in PACER. Those costs are passed on by because the Congress wanted us to do that, frankly. We were going to have to incur increased expenses in our budget when we went to Congress about providing information on PACER to the public. And the Congress decided, and I think wisely so, that those costs should be passed on to users who can afford the costs, and they're not extraordinary costs. And those who can't afford it should have access for free. So there is a user fee associated with PACER, but that was at the direction of Congress so that we didn't have to seek more money in our budget. We were going to have to pay for it somehow.
Yeah. Well, thank you, Mr. Duff. Mr. Chairman, thank you for being so gracious here.
Thank you, Mr. Franks. We now go to the gentleman from Ohio, Mr. Shabbat, for his questions.
Thank you very much. Thank you for being here, Mr. Duff. Sorry
Thank you.
I wasn't here in time to hear your testimony. We've got various hearings going on in different rooms around here. I'd like to follow up, I think, along the lines that my colleague, Mr. Franks, asked, and that's relative to cameras in the courtroom. Do you know what the number is, how many states actually allow cameras within the courtrooms?
I'm sorry, I don't off the top of my head, but we can get that.
Okay. Would you agree that it started out pretty small and has now grown to most of the states?
Yes, and I'm sure that's right.
Okay. What makes the federal level different? Why should we not learn from the experience that the states have had in this? And had they had a lot of problems, it would seem that that trend wouldn't have continued where they've opened up the courtrooms to the public.
I think there's been some genuine hesitation to open up, certainly in criminal cases, open up federal courts to cameras. There are a lot of concerns about how the trials are conducted and the impact that they have on witnesses. And,
well, let me stop there if I can. We'll put the criminal part aside for a moment then. But at the present time, in the overwhelming majority of the federal courtrooms across the nation, you're not allowing cameras in the civil cases either. Is that correct?
That's at the district court level, yes, sir. But at the appellate court level, there is a provision that would permit cameras.
Right. Would you agree that probably to most of the public, the actual trial itself would be more interesting for the public to see what's going on in the courtrooms that they, after all, pay for, than at the federal level, where it tends to be a bunch of lawyers talking to each other about fairly obscure legal issues most of the time, if it please the court, and it can. So wouldn't it be more interesting to most people, probably at the trial level to begin with?
Are you speaking of criminal trials or civil trials?
Well, let's stay with the civil for the time being, yeah.
Well, as I mentioned at the outset, any individual can go to any court in the country and attend a trial if they want.
Right, and let me ask you about that. Obviously, you've got people that that work, support their families, take care of their families, or doing what it takes to live in our society nowadays. Shouldn't we make it more accessible to the public, more convenient to them, so that if they want to watch, if it's the court TV channel or whatever they want to watch, shouldn't we leave that up to the public to make it easier for them?
Well, there are advantages and disadvantages, and I think the federal court system, they are considering this. They've been looking at it, and we've done a pilot program in it. We just haven't felt at this time that there's an overwhelming need or interest in doing it. I think the viewership in civil trials, frankly, is not compelling, a compelling reason to televise civil trials. There is a concern that it changes behavior in the courtroom. It changes the behavior of the judges and the lawyers as well.
Well, I know that was a concern. It was a concern at the state level that it would change the behavior. Maybe it changes it for the better, for that matter. But most of the studies that I've seen indicates that it really doesn't change behavior significantly. I mean, they said the same thing, and I know we're different branches of the government, but they said that about C-SPAN years ago, and that happened prior to me getting here about 20 years ago. And in general, we just take it for granted now. There's cameras there, and if you don't want to be embarrassed, don't do anything embarrassing in front of the cameras. And I would think the courts, and I think most of the legislation that I've seen, and that, to be open and honest, that I've introduced in the past to allow cameras in the courtroom, we would leave it up to the federal judge and the parties to determine if they want cameras in the courtroom or not. If a judge doesn't want it in the courtroom, then don't have it. But if a judge, and there are judges that do think that we should do this, although it's obviously not unanimous, maybe it's not even the majority. But it would seem to me that if the judge thinks that it's okay and that he can keep control, just as we have these cameras here, and the parties themselves don't have any opposition. It just seems to me, since the public pays for this, and they pay your salary and my salary, that they ought to have access. And I'm sure you've heard the expression about sunshine being the best disinfectant, and I'm not saying there's anything going on wrong in the courtrooms, but it would just seem the public ought to have access to those things. And then, so we talked about civil, and as far as I'm concerned, the same thing would apply to criminal cases, in so much as if you got a case, let's say it's organized crime, or it's some sort of situation where witnesses do need to have their identities protected, and of course the judge could, at the very beginning of the case, could decide this is the kind of case we don't want to have that, so no cameras on this case. And that would be fine. But Jerry Nadler, who was a Democrat, still on, I believe he's still on this committee. I know he's on the Judiciary Committee. Yeah, there you go. Right. Mr. Nadler over there, he and I worked on an amendment that he was concerned about that obscured the identity of witnesses to make sure that they were protected. So I just think that virtually any roadblock that's thrown up to say, no, we can't have cameras, it can be reasonably dealt with, and I think we ought to do it. So I hope you'll reconsider, but I'm guessing you probably won't. So.
Oh, actually, we have had the pilot program. The Ninth Circuit is continuing the pilot in the courts there that participated in it. We're going to continue to take a look at the issue. We have some concerns. I think there are some distinctions in the branches that I pointed out a little earlier as to the purpose of trials, and the public's interest certainly is very important, but the trials and the courts are there to serve the litigants, and it's a little different than issues on which the public at large have a vote. And so there are different considerations. We're looking at the state court systems and where they're successful. Our pilot program, though, was instructive in this way. When given the choice of to have cameras in the case or not, the vast majority, and I'll get the statistic for you, said no, that they didn't want them there. And that we're trying to resolve conflicts between two parties in the court system. And that's a little different dynamic, frankly. And while they're open to the public generally, I agree that it's not open to every citizen because they now can't come to one individual court and get in and see the case. But we're trying to find the right balance. We're going to continue to look at it. It's an important issue, and we're studying it within the court system. I do think I'll share something with you anecdotally, though, about the success or issues. And I know you've already committed, and I'm friends with C-SPAN, so I admire what they've done for the public. But I was at dinner one evening with Senator Howard Baker, for whom I worked for a number of years, and someone asked him, if you had anything to do over again when you were a majority leader of the Senate, what would it be? And he said, without hesitation, he said, I would never have allowed cameras in the Senate. And
Can I ask you what year that was?
this was
You can refuse to answer if it's incriminating.
This was, let's see, passed away 2 or 3 years, a couple of years ago. So it's been within the last 5, 10 years. But, there are advantages and disadvantages.
Speeches aren't as good over in the Senate as they are in the House anyway. So.
Yeah. Well, his point was, and this is a point I would raise, and we're having a good, healthy discussion about this. And I'm glad we're having this, because we want to have this conversation with you, and the more communication about it, the better. But I think that the Senator Baker's point was it changed the behavior of the members, because they used to get work done on the floor of the Senate. It was a buzz of activity. And now today you go into the Senate and with apologies to C-SPAN, there's one individual member speaking to a camera, and it's empty for the most part. This was his point. I'm paraphrasing his issue with it. And so he wasn't convinced it was a positive that the proceedings in the Senate are now televised on balance, because he thought they got more work done when there weren't cameras on the floor. So the point I would make about that is cameras do change behavior. They alter the way, I'm not as comfortable here today, frankly, because there's a camera, but I welcome it. But because I have nothing to hide, as you say, about sunshine. But when it comes to trials and cases involving litigants' interests, there's a different element that we have to take a careful look at, and what our purpose is in the judicial branch. And it differs slightly than the other two branches, is all I would add to that. And so I hope that you all could appreciate that aspect of it. We're not trying to hide anything. We're just trying to provide the best form of justice in the world to our citizens.
Mr. Chairman, do I have time to make a follow-up?
Absolutely.
Yeah. And I think that's the reason I think we in the legislative branch are trying to be as understanding and as accommodating as possible by saying we'll leave it up to the judges to decide whether or not in that particular case they'll allow cameras or not, or if they don't want them at all, that's fine. So that's about as accommodating as I think this branch could get to that branch. And final thing I would note is, in full disclosure, when I was chairman of the Constitution Subcommittee of this Judiciary Committee for 6 years, and shortly after our new Chief Justice was sworn in, Justice Roberts, I met with him over in his office over there, and we discussed this and a lot of other issues, but this one in particular with great gusto, and I did not win that argument. So in any event, I hope someday we will. Thank you.
Well, thank you, Congressman Chabot. And I want to mention I was just home last weekend for our 45th high school reunion and came into Cincinnati. I'm from Hamilton originally, but
Hamilton High School?
Hamilton Taft.
Oh, very good, yeah. Excellent. I'm a LaSalle Lancer, proud LaSalle Lancer, which, since this is on camera, I'll mention won the state championship, football state championship, the last 2 years in a row. LaSalle Lancers. Lancers roll deep, is what they say. So
I wanted to give you that opportunity. So.
I appreciate that. Thank you very much. I'm still not changing my opinion on cameras, but well done.
We'll work on it. Thank you.
Recognizing myself as a Clevelander, there's a lot to be said about, you know, the camaraderie of Southern Ohioans, the people who go to Kentucky to go to their airport.
Well, I will say that when I grew up in Southern Ohio, we didn't have the Bengals, so I was a Browns fan growing up. So
I was too, until they went to Baltimore. Moving right along, you know, we've had a lot of discussion about cameras, but I want to close the camera discussion with two, hopefully only 2 points. One is, repeatedly you said we serve the litigants.
Yes, sir.
Would it be fair to say you serve the American people, and particularly when you're dealing with criminal cases, you really represent, if someone is guilty, the victims, and if someone is innocent, then justice for the innocent?
Yes.
Which goes well outside the courtroom, doesn't it?
It goes beyond those participants.
So
certainly.
leaving civil cases, which are a big part of your caseload, aside,
Right.
I want to touch on just one area, and like my brother and I'm a former Ohioan, he's an Ohioan, but I've had that time with Chief Justice Roberts, and he is still as resolute as ever. But I'm gonna appeal to something today that goes beyond that. Justice when someone has committed a crime. Justice when someone goes up on appeal is best served when the greatest amount of information is available to the victims, their families, and of course, if appropriate, to the appellate court. And I might suggest that there is an in-between, if you will, cameras, no cameras. When someone proffers or, you know, admits their guilt, I'm saying it wrong, but I do that once in a while, or when they are in fact going through the process of the jury coming back, finding them guilty, and going through the sentencing, 2 distinct phases. These events are often, many of the family attend, some of the friends, but in fact they're not captured in perpetuity. And when 20 or 30 or 40 years later, someone who is on death row is saying, but I wasn't that bad, those moments are lost forever, and the family or the police officer or a lawyer comes in and tries to explain to a parole board those terrible, grievous, events. I might suggest that the cases and the outcomes drive a lot of the question of, is there a reason to capture it? Now, I will say, I'm from Southern California, and we have had video depositions as a mandate. You cannot get out of them under the local rules. And that has changed, I'm sure, how people answer questions, but it's also captured in a way that is usable as evidence. So I might suggest that as you go back and begin working with not just the Chief Justice, who we've talked about here, but with all the judges, and ask the question of, shouldn't we, at the soonest possible date, enhance the tools that remain in perpetuity for that 20, 30 years later when someone's, trying to say, I didn't really kill him, so to speak. And that value of those cases, and we're talking strictly criminal at this point, and the value in some cases for an appellate where somebody has said something and the visual is very powerful. So I might suggest that there's some middle ground, just as the court was kind enough to work on the pilot in the Ninth Circuit, that we don't yet know what the value of capturing those certain aspects might be. And I've had the luxury of talking to a number of federal judges around the country who have sort of brought that up, that they'd love to have the tool to use when they'd love to have the tool to use. You can respond. You're nodding your head yes, and we're capturing that on video, so I'm hoping that's a good sign.
Well, I thank you, Mr. Chairman. We will certainly continue to take a look at this issue. It's of importance to not only the branch, but to the American public, and we are stewards of their funds, and you're right, everyone has an interest in the outcome of cases in some fashion.
I want to touch on just one thing that I want your input on. It is clear that social media is now affecting jurors in a way that it didn't just a small part of a generation ago. How do you see the court being able to handle that, and are there additional tools necessary to keep a jury from being tainted under these circumstances of the proliferation of social media?
It's challenging. You have to be vigilant about it, and I don't know how it can be monitored entirely successfully. There have been issues that have arisen. I think for the most part, we're doing a good job.
But you still have iPhones for lunch, so to speak.
Exactly, and so it's a challenge to us. We have to stay on top of it to preserve the integrity of the jury system, and we certainly are committed to doing that.
Well, and my follow-up on that is jury pools are becoming more demanding.
Yes.
They're becoming demanding both at the state and federal. And when you look at the makeup of these pools, disproportionately retirees, disproportionately government workers, do we have, at the federal level, do you have the tools you need to get a jury of people's peers, or are you getting a subset of the jury of people's peers? Maybe fair and impartial, but certainly not the same cross-section of society as it would be if it were 100% at random.
Well, we're working on making certain that we do have the cross-section. We've added, and this goes to a point you made in your opening statement with regard to access and transparency. We've made it easier, we think, for jurors to be selected and chosen through our e-juror system. There's electronic mechanisms now to make that whole process work more smoothly. Can we do better? Sure, and we will work toward that. But you're right, the challenges are greater today because of social media.
The income you receive from that 10 cents a page, from our looking, there's very little transparency as to where the money goes in excess of the operating cost. Do you want to go through, just for people watching here today, I think, how you feel that it's appropriate not to have those funds come back to the Congress for appropriations, but rather be in funds controlled by your branch?
Well, the funds are intended to be put to use to improve the access to opinions and court records. And so it's rolled back into the costs that we incur for improving systems to make these available to the public. And that we have certainly talked with our appropriators about it, and will continue to do so.
I guess, can you assure us today that all funds are used within that system and that no funds are diverted to more general information? And in other words, it's not printing pamphlets about how great the court is, it's strictly providing access to this information that in fact you're charging 10 cents a page for.
Yes, sir. That's what we are, we intend to use the funds for, is to support that system. And, you know, there are tangential issues that come up that we think are appropriate for the funds to be used for, but they all really focus around access to the information.
Now, there's a couple of more that are also perennial issues, and I want to go through them quickly. We mentioned in opening statements that we've had judges who, under the Constitution, had committed impeachable offenses. As you know, impeachment is lengthy, laborious, and as you also mentioned, we can't take away a judge's salary while he or she sits and says, nah, 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 it'll take you a long time to get rid of me, by which time I'll be on disability or retired. Do you have any proposals for any kind of a faster administrative remedy for clear and convincing misconduct, other than a constitutional change or an expedited impeachment?
Well, let me...
And this is just recognizing that judges are human beings, and out of any set of human beings, no matter how well chosen, some will be awful.
Let me address, I think, a very good and serious issue you've raised with regard to conduct matters that come to our attention that are short of impeachable offenses, although some that have come to our attention we've referred to the Congress for impeachment proceedings, and thankfully they're rare, but they happen.
Judges normally resign if they've done wrong is one of the reasons we've had so few in our history.
I think that speaks well to the review process we have, and you mentioned the time it takes, and I would welcome meeting with you to elaborate on this even more with the chairman of our Conduct and Disability Committee, Judge Sirica, and would welcome the opportunity to walk you through a sort of a typical conduct review, some of which I'm restrained from speaking about publicly because there are confidentiality requirements built into the statutes that give us authority to investigate allegations of misconduct. And we're not permitted to reveal publicly some of the aspects of that. But just speaking generically about that process, I think it's a very healthy and robust and thorough process that we have within the branch. And I think it was Chairman Goodlatte who raised the matter in Alabama where the judge did resign. From beginning to end in that particular matter, that took 1 year. And you might say, well, why did it take that long? Well, in that case, from the time the allegations surfaced...
I just want to...
Yes, sir.
The timeline of 1 year, that's the timeline of the investigation, not the timeline from beating his wife to removal, is it?
I think
that was slightly longer.
I believe it was when it became public that he was arrested, and then that was the issue to the time of resignation was about a year. And in the course of that, there was a thorough investigation. There were witness statements taken, and throughout the process, if I can be brief about it and summarize it, from the time a conduct complaint was filed, misconduct complaint was filed with the chief judge of the circuit, the chief judge of the circuit then brought it to the attention of the judicial council of that circuit. The judicial council of the circuit, then there was created a special committee to review the matter within the circuit. The special committee reviewed it, made its recommendations to the judicial council of that circuit. Those judges then, and the chief judge of that circuit, made a recommendation to the to the Judicial Conference of the United States, which then referred it to its Conduct and Disability Committee, and it reviewed the matter, and then it, at that time, referred the matter to the full Judicial Conference of the United States. All in all, 54 judges were involved in the review of that conduct allegation. It ultimately resulted in the resignation of the judge. That took a year.
And we verified, you're exactly right, it did take a year. So thank you for clarifying that. One quick follow-up on that, and then I think Mr. Cohen's going to ask a round of questions.
Sure.
The Constitution does not allow us to reduce the pay of a judge. But there is, as far as my reading, no prohibition on an ultimate reduction for someone terminated for cause. Effectively, if we passed a statute that required that once someone went into a, quote, investigation, that if that investigation led to their resignation or their dismissal through any number of procedures, including impeachment, that their retirement date would cease as of the date of the beginning of that crime or misconduct. In your opinion, that is, would you say that's not a diminishment, or if it was, we could certainly define retirement in a way that it wouldn't be? And I asked that, I shared that with a number of judges, because one of our challenges has been individuals who choose to say, I'm going to be vested or vested at a higher level, and they simply delay the tactic, and that often leads to judges saying, well, why go through this if he or she is going to be gone in 18 months? That is a tool not presently available to you. Can you opine on whether you think that would be constitutional, or whether you would need a statute and then still a constitutional challenge to, I guess, 8 men and women?
I'd like to study it a little more before, and I'm not sure it's proper for me to speak to the constitutionality of it, but I would be very interested in working and talking with you about it.
We're going to go to Mr. Cohen, but I wanted to leave that public because it would seem that it is a tool not available to you today. It would seem that the retirement system, different than the current pay, may well be one in which we could define that ultimately that, we can suspend an employee potentially without pay in the executive branch. We have no such ability. In Congress, we passed the statute after Randy Duke Cunningham essentially took bribes that would make it possible to eliminate their retirement altogether for that crime which he pled to. So it's not that we're not doing it to ourselves. We are doing it to ourselves, but we lack such a tool currently. So if you would study it, I'd be happy to work with you and at some future hearing perhaps bring it up again.
Very happy to do so, Mr. Chairman.
Well, and now we have the gentleman who represents St. Jude and other important areas of Tennessee for his questions. Mr. Cohen.
Thank you, Mr. Chair, and indeed I'm proud to represent St. Jude and this 9th District in Tennessee. The 9th District of Tennessee has a district court judge that is pending in the United States Senate. President Obama nominated the present United States Attorney, Ed Stanton III, who has an impeccable record, outstanding job as United States Attorney, formerly a counsel with Federal Express and in private practice as well, and a esteemed graduate of the University of Memphis Law School and undergraduate. He is next on the list. How has this, do you have any insight into what the Senate's rationale is and what they will do as far as having more nominations come to a vote that have been approved by the Senate Judiciary Committee and are pending the final vote in the Senate? Do you have any idea what their present perspective is? Are they limiting themselves by the number of people that were approved during Bush's last year, or are they trying to help the federal courts get judges who can then make the flow of cases proceed?
I don't know, Congressman Cohen, what the intent is from here through the election. We continue to encourage and press for the vacancies that exist to be filled. And there are some nominations pending, and we want the vacancies filled, so it's...
There are 90, as I understand, vacancies with 59 nominees pending. Some have been there for more than a year. I think Mr. Stanton's been there obviously the longest time, I think, because he's next in line. How has the lack of filling these vacancies affected the workload of the current judges and federal district courts?
Well, vacancies have been with us for a long, long time, and it's an issue that we work on with every administration, regardless of party, and we push for getting those vacancies filled as best we can. This is not a new issue for us. Our workload is, as I had mentioned, that we're really beholden to our senior judges for helping us absorb increased workload. If you look at the trends in the federal courts over the last 50 years, the workload has gone up probably fourfold for the courts, and yet we only have twice the number of judges that we had 50 years ago.
So let me ask you this. So the administration of justice is being harmed by not passing and approving judges who have been approved by the committee. Would that be an accurate statement?
Well, we do want the vacancies filled.
Okay.
Yes, sir.
And let me ask you this. At one point, I think the rationale was that X amount of judges were approved in the last year of President Bush II, and that I think they've gone beyond it by one or two now. Do you know what the caseload vacancy was at that time? Or not the caseload vacancy, but the judicial vacancies. There are 90 vacancies now. Do you know how many vacancies there were at that time?
Off the top of my head, I don't, Mr. Cohen.
But I believe there were a lot less. So I think that's a better way to look at it, is the harm to the judicial system and not just a raw number. And I think it's an error. And of course, I'd like him to approve Mr. Stanton and at least do one more. The issues come up about television in the courtrooms.
Yes, sir.
And as I understand it, y'all have a pilot program, but you're not so much in favor of it. And did you take a position you didn't think it should exist at the Supreme Court level?
Well, our pilot program really has nothing to do with the Supreme Court.
Well, I understand that, but did you take a position on the Supreme Court and cameras?
No, sir.
Okay.
The Supreme Court makes its own decisions about
I might
that.
note for the record that Chief Justice Roberts has not changed his adamant opposition.
Well, and I have great respect for Chief Justice Roberts. I've had the opportunity to have interchanges with him on several occasions. I respect him greatly, but I think he's flat wrong on this issue. I can see people being against it, thinking that in certain places that some lawyers might use it to, act and maybe increase their client base, et cetera. But I don't think that's going to happen at the Supreme Court. The government body, the three equal branches, they're not three equal branches. There's one big branch, and it's the Supreme Court. They make more of a difference in this country than the executive or the legislative, in my opinion. They decided Bush v. Gore. They decide Citizens United. They've got choice. They've got the Second Amendment. They've got all the big issues are there, and they do it. And the American public should be able to see the arguments, listen to the arguments, and see the responses, and see the questioning. I've only been up there once. It was an edifying experience, and every American should have it, and you shouldn't have to go over there and sit there and to watch it. It should be on C-SPAN. I have no more time, so I'll yield back the balance.
I thank the gentleman. Do you need more time?
No,
Okay. Mr. Duff, I want to not get you out of here without thanking you and all of those who work with you for the fact that the cost of courtrooms is high, the building security is high, and in the now 15 plus years since 9/11, a lot of demands have been placed on those building funds. And I want to make it clear that the dozen or so $1 billion, which in Washington, everywhere else is a lot of money. In Washington, it is amazing that the courtroom security, everything, and I recently dealt with one related to just getting the babysitting, if you will, into the federal building in San Diego, because in fact the place we had, which was secured, was being taken back by the city, and there was a basic problem of these are high targets, and how do you transport people who are targets between dropping off their child in one place and another? And I think the American public doesn't fully appreciate the actual security requirements that you deal with every day. So as a result, I'm not spending a lot of time talking about your building funds, your construction, because I think that you, between the appropriators in this committee, have been great and transparent. But speaking of transparency, everyone up here on the dais fills out, and everyone in the executive branch at certain levels, fills out an incredibly detailed but confusing form for financial disclosure. And it doesn't happen the same way in judicial branch. And I want to know from you, can you find and give us any guidance as to why we should not mandate, if we cannot get voluntarily from the court, a similar level of transparency for the question of possible conflicts of interest? We understand that a judge's job is to say, oh, I have this conflict, I own, 8 million shares of something belonging to somebody who's a litigant. But in fact, money flowing in and out is not necessarily that transparent sometime. And I'll take one example in my question for the public. I do not know who paid for trips by various justices and judges on a regular basis, because it's not disclosed with the kind of transparency we have. And my understanding is there is much less limitation on who can pay for and have somebody be their guest speaker at a first-class resort. So would you touch on that? Because people pretty much understand the president's disclosure, even candidates' disclosures of their tax returns. They certainly can go online and see the outcome of our extensive requirement to provide information not only as to our financial well-being, but disclosing every single individual stock trade within a very short period of time, for example.
Well, we do have, our judges do fill out financial disclosure reports, much as you do. There is a provision that permits when someone has sought access to the financial, or wants to review the financial disclosure report, there's a period of time in which we alert the judge to that, so that there's an opportunity to review it once again for information that could be redacted that would put the judge in jeopardy or his family in jeopardy by disclosing certain locations.
But in a nutshell, they file a financial report that is not public. If someone wants to review it, there is another round available to the judge prior to someone being able to see it, and those redactions, in good faith, might be appropriate, but that's not the same as a member of Congress buys 1,000 shares of Google today. It has to be reported.
Right. Well, those things are reported again in the annual disclosure reports. I think the redaction period is only about a 30-day period, and it was really implemented for security reasons for the judges. We did have an incident, we've had more than one incident of judges and our family members being killed, and so
we understand the addresses, although our addresses are very public. But let me just one more follow up on this to make it clear. If Judicial Watch asked for every single judge's financial disclosures so that the financial holdings in some range were available, 30 days from now, would they be able to publish those on the internet so that everyone would know?
I believe they do. I'll check into that, but I believe they probably already do that. I think those are well publicized. It's a mechanism for, and it may well be Judicial Watch who does that. But I'd like to follow up on that if I might, Mr. Chairman.
Okay.
Here's
the last one. And this one I've voiced before the conference, judicial conference once. We have a problem in Marshall and Tyler, Texas. Judges, by any stretch of the imagination, are abusing discretion to keep patent cases in vast numbers there. They do not transfer them, and they will not prioritize the motions to move them to a more appropriate venue, but rather they go through discovery. It's good for Tyler, it's good for Marshall, it's good for the Chamber of Commerce, and your federal judges are doing it not on an individual basis, but on a group basis. It has been going on for a decade. It is a growth industry. I am currently being asked to provide more judges to that district. Now, it will be a cold day in hell before I give more judges at my authority, to the extent that I have it, in any way, shape, or form to an area that is abusing discretion and causing legislation, chairman's legislation, vastly bipartisan, the ranking member and others, looking at legislation to try to stem misconduct within a district. So my question to you today, and this was a question I've asked the Chief Justice and the late Justice Scalia and others, if you have the power to do administrative, you can move cases, you can, in fact, speak to your brethren, and you have not been able to handle this, then why is it that it should be our problem and not your problem to fix it?
Well, you and I have had this conversation before, too.
Well, I got to tell you, I talk to everybody because it's frustrating that Congress should even be looking at one district for its misconduct.
Well, if I
And
may-
misconduct is a word maybe misused, but the growth of these cases and the other judges around the country rolling their eyes about Tyler and Marshall in the Eastern District of Texas, it's the most open secret there is on your side of government.
Well, if I might speak to it in a general sense, what the Judicial Conference, through its Rules Committee, has done most recently in this realm that may have some impact on it, although it may not address entirely concerns you've raised. But we have tried to streamline legislation, make it more efficient with regard to motions, for example, the discovery periods, bringing those into certain bounds and limitations that move cases along more quickly and make it more, the consideration of motions to be moved along more quickly than they have been. Similarly, we eliminated some of the forms in the rules, the civil rules amendments in 2015. One of the forms eliminated was Form 18, which was a form that was used for patent filings, and it was deemed to be not or no longer valuable and useful, and perhaps didn't give all the proper elements of a patent claim in the form itself. So that form was abrogated. And so we're taking a look at this, and the FJC is studying patent litigation and potential reforms. I think your institution and encouragement of the patent pilot program, there are elements in the patent pilot program that I think we can glean information from that may well help us address this more specific issue that you've raised today. And so our 5-year report is due at as you know, because you were a major...
You know, you're doing a great job of sucking up to the chairman here. But, you know, the fact is that Patent Pilot was designed to recognize that judges can in fact move caseloads better, that we want judges that are knowledgeable. The challenge that we face today, and I'm going to go to Mr. Johnson, but we also know that we want cases to be found, you know, that we want them to either be where the plaintiff clearly has a logical nexus, the inventors, et cetera, or where the defendant has a primary pace of business. And that's just a general rule that when all there is a donut shop that's using a product by a manufacturer and it's in Tyler, Texas, that's not where the plaintiff or defendant is, not where the invention is, it's not where the witnesses are. And it's frustrating because, and I have, as you note, I've been both a plaintiff and a defendant in these cases, and I know how burdensome it is to move people to a completely inappropriate place. It's always burdensome to have it in the other guy's place, but if it's going to be the other guy's place, at least I want it to be the appropriate other guy's place. I appreciate your kindness and you're working on it. We'll continue to monitor it. It happens to be important to the chairman of the full committee and the ranking member, so I will keep bringing it up.
Sir. And I do think the 5-year report that is due may address some of these issues, and we would hope to work with you on that.
Well, and I would note that there has been some progress on the caseloads reduction and transfer, so it's not without some upside. Mr. Johnson, are you ready? The gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, the ranking member as well. And this is a very important hearing, and I thank the witness for appearing. As a senior member of the House Judiciary Committee, I have long championed the issues of access to the courts for all citizens, not just the wealthy and the well-connected. Specifically, I have worked to ensure that every American has the opportunity to assert his or her right, a constitutional right under the 7th Amendment, to a trial by jury. Over the last 15 years, we've witnessed repeated attacks against our judicial system. The courthouse doors have been shuttered or threatened to be shuttered by legislative maneuvering and highly politicized Supreme Court cases. Indeed, very limited funding, significant legislative reforms, paradoxical pleading standards created under Twombly and Iqbal, an aging bench, and anti-litigation legislation here in Congress makes me wonder how capable our venerated judicial system is at administering justice in the face of all these hurdles. In the 11th Circuit alone, we have 11 vacancies, 4 future vacancies, and 7 judicial emergencies. Furthermore, prosecutors and public defenders at the state and federal level are facing significant funding cuts. To avoid layoffs, public defenders find themselves working unpaid cases, facing delayed compensation or enduring furloughs. Advances to court technology have also taken a back seat, despite the fact that such measures are needed to make the courts more accessible. While this is in response to tightening budgets and sequestration, it has a corrosive effect of increasing court backlog and discouraging citizens from seeking redress through the courts. Rather than making the process more streamlined for the public, Americans face higher litigation costs, a confusing process, and longer wait times between proceedings. Instead of reaching a speedy resolution, citizens find themselves frustrated and disheartened by the legal system. And I'm glad that we have an opportunity today to hear how Congress can support the courts, give rights back to the people, and ensure everyone has the opportunity to have their proverbial day in court. Mr. Duff, while the Senate has grown famous for its stalling tactics in this year's SCOTUS nomination, they also have a historically low confirmation rate for all federal nominations, only 11 in 2015. How does this appalling low confirmation rate, combined with an aging bench throughout the federal judiciary, affect the court's ability to administer justice? And I think closely associated with that is the rate of pay that we give to judges. I mean, they make less than a first-year associate at a major law firm these days. Can you comment about that?
Well, you've raised a number of issues, and I'll try to address them in order, and maybe reverse order, because I'll remember more easily then. But I want to thank you for your efforts in years past for our judges and the salary issue. You were a leader on that for us, and it was very much appreciated in the branch. With regard to vacancies, we across administrations, we have pressed for filling the vacancies where they exist. We need our judges to help us with the workload. You referred to also our aging bench. I would reiterate something we discussed a little bit earlier, which was our senior judges are the reason why we're keeping up with the workload to the extent that we are. We have a number of judges who are serving who could retire and draw their salaries in retirement. As you know, with a life appointment, that's possible for our federal judges. But most, if not, and many, if not most, stay on the bench even after they're eligible to retire. And that's been an enormous service to the country and to the judicial branch. But you've raised other challenges that we do wrestle with. I want to mention that after sequestration, we have been very, I hesitate to use the word favorably, but certainly given very healthy budgets in the last 3 cycles. They're enabling us to pay defenders now, where through sequestration we had to make cuts. We're very grateful to the Congress for the appropriations we've been given over the last 3 years, and I think that's a reflection of recognition that we've been good stewards of public funds. And if I might correct the chair on something, I hesitate to do that, but
Oh, please feel free.
well, I would love to have a $12 billion budget, but ours is $7 billion. So, but if we had 12, and it may be that you're referring to courthouse construction projects and others that GSA gets
Yeah,
funded
I was
for.
lumping all of it in. You know, some of it goes to those
Right.
underpaid federal judges.
But we've been given healthier budgets in the last 3 cycles because I think our appropriators have recognized that we are efficient, which was the topic of this of the hearing, the efficient administration of justice, and we're grateful for that. Could we use more resources? Sure. Do we need more? Do we need the judges filled? Yes. The vacancies. Do we need more judgeships? And we've focused on areas where there is an extraordinarily high caseload, and we've asked for more judgeships in some key districts around the country where the caseload is overwhelming to our judges. But if I could speak to what the branch is doing to handle that within the branch, we are utilizing inter-circuit assignments of judges and intra-circuit assignment of judges to move judges whose workload may not be as heavy in some districts into courts where the workload is overwhelming. And so we're trying to manage within the branch without getting more funding from Congress and more judges, frankly. We're trying to manage within the branch the increasing workload. And we don't have as many judges workload-wise as we did 50 years ago. If you look at the case trends and the growth in the cases in the federal courts, and the number of judges hasn't kept pace with that. But we've become more efficient, and I'm very proud of our judges and the staff for the hard work that they put in around the country. But you've raised serious issues and questions. They're ones that we take to our appropriators as we go through our budget process. Many of these issues are, money doesn't solve everything, but there are areas where it's needed. We've asked for more, and the Congress has been responsive for the most part. So we're encouraged about that part of it, but there are other elements that you've raised that we have a long way to go yet.
Well, the issue of judicial pay, if you would get a little bit further into that, tell us what the lay of the land is in terms of judicial pay, how it incentivizes or disincentivizes good public service?
Well, our pay has been adjusted. The cost of living increases that were denied over past years have been reinstated. And so adjustments have been made that have made up for the lost cost of living adjustments. And so the pay issue that you and I worked so hard on a few years back has been alleviated to a great degree, but it is certainly an issue, I think, for public servants generally. The rate of pay, your salaries, are I think, frankly, in need of review. And so that's an issue that, thankfully, within the branch, because of the makeup on the lost COLAs, has been relieved somewhat.
Well,
But it is important, as we've talked in years past, it's a very important incentive to get people into public service. Not that people don't devote their careers to this to get wealthy, obviously. They're devoted public servants, and they want to serve the country. But to attract the best, you have to be at least competitive with a cost of living in an area of the country, certainly here and in major cities, that you can attract good people to the service. So it's a very important element of public service, and I think it's deserves consideration. And it's not at a time, of course, when that's going to get a lot of sympathy. I think the chairman alluded in his opening remarks about the views of the public about our public service generally, and the low regard of the polls would indicate. We've got work to do to persuade the public that we are serving them well, and then we can look at the pay issue again, I think, but not until.
Thank you. I want to thank the chair for being quite judicious with, or more than judicious with the time for my questions.
The gentleman's questions were
Thank
very appropriate. I thank the gentleman. In closing, I will recite from my prepared notes, 13.29 billion is the budget. Much of it not discretionary. Obviously, you have pay, you have retirements in that. About less than half of it goes to the court operations as you would oversee it. And I bring it up actually because it's so small. You are a very small branch of government. The total amount that is allocated, considering there's 320 million Americans, is small. And I'm going to close with a comment, but it's one that I wanted to make sure is on the record. The growth of the use of the federal court system, far beyond what it was ever intended to adjudicate, is part of the reason that we today spent a considerable amount of time talking about federal judges and the 90 or so vacancies, 31 not referred yet to the Senate, but the remainder who penned before the Senate. If we took every gun case, every car theft case, every civil suit that could be in state court, what we would discover is the vast majority of that, other than immigration, considered by the court, and I'm leaving bankruptcy and the specialties out, would in fact not be there. As someone who has watched patent cases be put behind endless amounts of criminal cases, all of which are illegal in every state in the union for crimes committed in a single state, what we discover is that we in Congress have, in fact, given you a growth opportunity that we have not fully funded and are unwilling to fully fund. So I might suggest in closing that a future hearing by this committee and a series of looks that go along with Chairman Sensenbrenner's view that we need to take a close look at why we federalize that which the states could do, why we ask our federal judges to spend a great deal of their time reliving their time as DAs and state judges, rather than focusing on immigration, patent, true interstate activity, and other areas that would only be possible to be tried in the federal courts. That's sort of my talking point close. At this point, I'd like to thank our witness for his very lengthy discussion. It's been very helpful. This does conclude today's hearing, but without objection, all members, both present and not present, will have 5 legislative days to provide additional written material and, with the indulgence of our witness, provide additional questions and follow-ups that you may be able to answer.
Happy to, Mr. Chairman.
I thank you, and with that, we stand adjourned.